Welcome to Tech Tuesday number 33. Before we start, we're going to take a moment of silence in view of the ongoing hostage situation. Today we're going to explore what IP does to other companies, not your company. And I put it in the context of information wars, because IP has a lot to do with information. And perhaps the two important things you can do with IP is you can interfere with the ability of a company to create and apply knowledge, and you can interfere with the ability to make and sell products. Now, I'm sure you notice that the first one is in the realm of thinking, and the second one is in the realm of doing. Of course, different kinds of IP do it. And I talk about interfering, but at the same time, IP can be used for constructive purposes, like collaboration and guiding. And when you use it for constructive purposes, what you're actually doing is assisting in the ability of a company to create and apply knowledge, or assisting with the company's ability to make and sell products. And just to give you an example, if you buy pajamas that have My Little Pony pictures on them, well, whoever licensed My Little Pony copyright, trademark rights, got assistance in making and selling pajamas. So one way of looking at this doing and thinking is look at it as both the map and the territory. When we file a patent, the patent talks about the map. The idea of a product that has component A connected to component B. But when we use a patent, what we're doing is we're trying to prevent a competitor from actually making, using, or selling a product that has component A connected to component B. So we have both the map and the territory at the same time. Now, I'm using the word IP in a very nebulous way. I'm covering both intellectual property rights and other intangible assets, including ones that you can't protect. You know, if you have an insight, there's no law which protects your insight, but also copyrights, trademarks, patents, trade secrets, and so on. Now, I talk about map and I talk about territory, four very important spaces which do not actually exist, they're all metaphorical, are shaped by IP. One of them is problem space. What are the different problems that we know about and that we want to solve? The second one is solution space. What are all the possible solutions to a problem? One of them is opportunity space. Basically, where can we go from here that's good for us? And more generally, is possibility space. What is possible to do, whether or not it's good? So how does IP shape all of these spaces? The answer is, it helps and it hinders. And both helping and hindering actual doing, and also helping and hindering knowledge flow. And because it's IP, it has all sorts of special twists in what you can do and how you can do, and that's really the subject of today's IP Tech Tuesday. So you might have heard about the seven friends that have W, who, what, why, when, and so on. So IP, in a very natural way, covers that, which is in a W, how, what, and why. And it also covers a little bit of who, in other words, who can do it, when you have the rights, where, what country, and with what are you doing it with? So if we want to look at it in a more focused way, IP says what you may not do. May not do. A patent tells you what you may not do. But it also tells you what you cannot do. Okay? I'm assuming nobody in this meeting knows how to add salt to water and make it flammable so you can use it as a fuel. Okay? So you cannot do that. But I have a trade secret and I know how to do it. So if I tell you how to do it, you will be able to do it technically. So as long as I don't tell you, you cannot do it. But once I do tell you, you can do it. And we live in the real world. There's no black and white. It's all intermediate amounts of may not and cannot, which means you have a certain amount of risk, uncertainty, and cost with regard to resources and time. But that is what IP does. Okay? Perhaps this is the only thing that IP can do, telling you what you may or may not do and what you can and cannot do. Two more things. So, if you don't know how to do something, and that makes you think of trade secrets, it can stop you from doing it. It can even stop you from knowing that you might want to do it. And this idea of preventing your competitor from knowing that they want to do it, or making them less likely to know that they want to do it, is a very important component in the information warfare, which, at least in our space, is mediated by IP. And I mentioned in the talk on trade secrets, many problems are caused, Mark Twain says it, by what you know that ain't. So if you know something about technology or something about how much time you need or resources and risks, but you're wrong, that can really interfere with your business. And that's what we're talking about, is interfering with the competitors and helping collaborators. So does IP work directly or indirectly? IP makes promises. I'm going to give you a monopoly. Or IP increases or reduces your risk or uncertainty. So that is directly. It doesn't sound, very exciting. It gets a little bit more exciting when we bring in third parties. For example, if I motivate the momentum of third party to do something, that can have a very significant value, and I motivate them using IP. Recent example, Tesla saying that if people act in good faith, and it doesn't matter what that means, they can infringe the Tesla electric vehicle patents. So that is an IP move. We're giving a license. We're telling you what you may do. And what we expect that to do is to cause more companies to build, let's call it Tesla compatible components and services, because they'll be using the same technology. That, of course, is good for Tesla, but the people doing it are the third parties. And the ways they're doing it is because IP is telling them what they may do and motivating them to put their energy into doing what's good for them. Another classic example is the App Store, Apple's App Store. They motivate companies to build an app and Apple not only gets a nice hefty kickback, but also it increases the value of the iPhone ecosystem. Other types of business moves also can interface with IP. And I think the four main ways of how they work together with IP are forces pushing in the same or coordinated directions. And the examples that I like is we have regulation, which says you have to go all the way to here, and we have IP, which says you have to go all the way to here, and there's nothing left in the middle. So pushing regulation in a certain direction and pushing IP in the same direction can together have a nice effect. Or I can do carrot and stick. If you infringe my patent, I will sue you. Okay? But here I'm giving you a free product you can use where you're not infringing my patent. So we're having two forces pushing in coordinated directions. There's also filling in of holes. Usually when you have IP protection, it's not complete. It has, pieces missing. You can fill in what's missing using a different type of business move. Again, incentives or business threats. There's the issue of providing a complete story. If you think about what's happening today with Meta, they're trying to push their vision of the metaverse. They're simultaneously providing technology, which is protected using IP, and marketing, which of course does involve IP, but as from a business perspective, the marketing activity is not an IP activity. But together, they're giving a complete story. Apple, of course, has their own competing complete story with their own technology protected by patents and their own marketing activities, which are something different. And last but not least, something I call IP-related landscape, which I'll talk about in a slide or two, and the actual landscape can be modified by a business move, or vice versa, can be modified using IP to make other business moves more likely to work. I'm not going to go too much into that. So while what I described, again, seems a bit boring, the actual ways you can apply all of these different ways that IP works are only limited by imagination. And every day we find something new that somebody did which is worth copying. And one of the ways is using leverage, which I will talk about again in a few slides. So before I continue, does IP always work? Everybody knows the answer is no. We filed a patent, it was designed around, and so on. So IP is probabilistic, and the world itself is a very messy place, so things don't always work so well. But more than that, the strength of your IP and its efficacy have, I'll call them preconditions, but they're basically IP-related landscape. And let me give you a few examples. If novelty isn't part of the world, IP might have difficulty. In other words, if I'm going into a market and nothing is new in that market and nobody wants anything new, it's difficult to get IP which can affect my competitor. Because if my competitor is not changing or does not need to change, I'm stuck. And the novelty doesn't have to be in technology, it's sufficient that it be in the market changing. We sold pajamas for kids and now we're selling pajamas for grown-ups. So there's some novelty and we have something to work with. IP requires you to know or shape, but we'll talk about knowing the future. If you don't know the future, any IP you get might be meaningless, and the future includes lots of stuff, including publication and IP and competitors and partners in the market, and the will to do something, and available technologies, and what customers want, what regulations might happen. So if you don't know what the future is going to be, your IP is less likely to work. I mentioned shaping. People hopefully not only live in the future, but we actually shape the future. The more we can shape the future, and of course a company like Apple or Meta can do it much better than a small startup. And especially if we shape what the ecosystem is going to look like or what technologies are going to be available. AT&T did that very nicely for many years. Also IBM. Then the IP can become more valuable. A lot of the effect of IP, I mentioned what you cannot do and what you may not do. Some people, when you tell them you're not allowed to do that, they do it. I don't know if you have kids, but you know what I'm talking about. So IP has a psychological effect, and it means that the people on the other side have to be scared of infringement. It depends on how they make decisions and other things. Of course, if we want to use IP against a competitor, we have to know something about the competitor, both the generic competitors, if the actual competitor doesn't exist, and the specific competitor. We need to know what they need, and we need to know what's actually going on. If we don't know what they need, it's difficult to interfere with what they need or help what they need, okay? Maybe we want to help them. And if we don't know what's actually going on, we can get great IP for what they need, but they're just doing something else. So there's a whole issue of knowing the facts. And the goal, if you can, is to shape the IP-related landscape. That's all of these. For example, you take a market where there's no novelty and you inject novelty, and you change the market and the landscape, and then, of course, to take advantage of that shaping. And that brings us to leverage, because the whole point of taking advantage of the landscape is to leverage it somehow. So how do I define leverage? I'll define it as obtaining an outsized effect relative to the applied force. I know, vague, but you can perhaps get it better if we talk about controlling versus mass. Okay, you get up in the morning, you walk down the street, there's a car with no driver going down the street about to hit a kindergarten. What do? One possibility is you run against the car and you try to push it sideways. Okay, that's called mass. You file 10,000 patents, one of them is going to have an effect. Other possibility is control. You go into the car and you turn the steering wheel or you press on the brake. The car stops. So leverage is when you do the smart thing. And mass is when you're strong enough not to care. So the effectiveness of IP comes, at least in part, from selecting good leverage points. What makes a point good? First of all, where it's located. Second, it's a task, not a job. It's a particular task. For example, preventing somebody from knowing something, preventing somebody from doing something should match what the IP can do. Remember, trade secrets and patents and brands are different. The reliability of the IP, not all IP is reliable. How the landscape is and changes. Other entities, we talked about motivating third parties. And you have to choose a leverage point which relates to the mind of the whoever it is you're trying to leverage. Which means that the leverage can be applied in the real world or it can be applied in people's heads. There's a famous author, I think she passed away, I'm not sure, Donella Meadows. And she wrote books and articles, and this one is leverage points, places to intervene in a system. Now, I don't quite agree with everything she said, but she definitely has a approach for how to take a system, meaning different things that work together and have a relationship, and identify what is the leverage points where if you apply control, you're going to get the desired change in the system. And the first one is people making decisions. Okay? So if I have a competitor, the competitor needs to make decisions. My IP can affect the decisions and the actions done by the decisions, and different IP at different time. So in a very simplistic manner, which probably is not connected to the reality of decision making, but is connected to formalized decision making. First, you collect information, then you evaluate it and decide to act. Then your acting gains momentum, starts using up resources and commits you. Then you get to what I call the stampede stage, where you're just rushing along, and then you're done. So in collecting information, this is the basis of information wars. If I make sure my competitor does not know certain information, if I distract them, if I hide information, if I hide the need for a decision, that's the type of IP to apply at that stage. When the competitor is deciding to act, a basic thing you do with IP is increase uncertainty and risk. You say, oh, there's a patent. There's a patent. Maybe you'll be sued. Of course, go up. More interesting is suggesting pathways which are less risky. Okay, if somebody's making a decision and he has two options, one with high risk, one with low risk, some of them are going to take the one with low risk. In any case, now is the time to convince your competitor, if you don't want him to, not to enter your field, because they haven't committed anything yet. Once they gain momentum, they've already started committing. It's not too late to show them, and sometimes it's the only time you can do it, that you send them a letter, I have a patent. You're running straight into my patent. Okay? You have risk. Stop what you're doing. In particular, you're giving them a warning that if they continue in that direction, they might get stuck and have a lot of damage to the company by the company committing to make a device which they can't sell. Stampede stage is when it's already too late to do that. In stampede stage, the company is committed. They can't, your competitor, they can't change what they're doing. You can sue them. You might get an injunction. You can definitely cause pain. They can cause pain to you. Okay? And now the best type of IP to apply is the IP which gives them a way to divert the energy to a different alternative way. But by now it's all out war. And when it's done, okay, the action is done, usually you have settlement terms. And they, of course, can be based on IP. And the IP can allow alternatives or not. So what I'm showing here is this basic sequence of decision-making and how different IP can and should be used at different stages for different purposes in order to affect your competitor. It's not the only type of, let's call it, low-level habit. One of them is the OODA loop, which I've mentioned in the past. And the OODA loop is basically the decision-making cycle. You observe, collect information, orient yourself, decide, act. That's not a loop yet. And then you observe again. So if this process takes a month for a competitor, and you do activities that take 2 weeks, then you interfere with them being able to carry out this OODA loop. Not going to talk about it today. What I will talk about is that just gave you some general statements about, oh, you can interfere with a competitor, but a typical company, and no company is typical, has several cycles which happen in the company and which have natural places to interfere with or to help using IP. And the financial cycle is getting money, information cycle, product cycle, you have to sell product, growth cycle, most companies want to grow and get better. Operation security cycle, the company wants to stay alive. Before I present them though, usually when we talk about IP, most people, not all, focus on the product. What's the product made out of? How is it used? And then we have the classic IP strategy, which is denial of critical components. So we have a car, and I get a patent on a wheel, and then my competitor can't make cars because you can't sell a car without a wheel. And to make that slightly more general, this is from concert.com. They have a lot of interesting articles. A trilogy: basic underlying technology, functional technology, which is a component, and application-specific technology. They brought that as an example for software. But again, it's focused on the product. And sometimes people try to get protection for the manufacturing method, usually trade secrets, or for disposables. Now, this is super important. It's very visible because anybody can see the product being used, and sometimes you can just buy it and show infringement, but it's only a very small part of the story, and I want to help you look in other places. So here's a knowledge cycle, and any high-tech company has to do this. You have data, you improve it to get information, you improve it more, you get knowledge. Knowledge on its own doesn't have that much value, usually. But if you have a problem, together with the knowledge, you get an idea. Now, in some cases, you just solve it. In some cases, you figure out what implementation you have to build, you make a product out of it, you use the product, and after you use the product, you get more data. And it happens again. Okay, this is really a virtuous cycle which has to be done. And our job as patent attorneys is to either help our friends do this or to prevent our competitors from doing it, or perhaps to help them do it in a way that turns them from competitors to assistants. So here's a few examples. I couldn't have a patent which interferes with how you collect or process the information. I could protect the data using a trade secret. By the way, I don't have to use IP. I could have an agreement with the person who generates the data that they don't give it to anybody else. They don't give it to me. They just don't give it to anybody. I can have know-how and how you convert information into knowledge and how you extract insights. And when I say know-how, there's also know why, which is why you're doing it, know what, and of course, know-how. I can get a patent on how I obtain the usage data from the product. If my competitor can't obtain the usage data, they can't complete the cycle. I can get a trade secret. How do you move from an idea to an implementation? I have my own proprietary ways to improve my database acceleration system within 2 weeks. And without my special secret incredible way, it will take the competitor 3 months. Okay, very valuable trade secret. And of course, the insights that we extracted before and false starts telling me what not to do are also things that I want to protect and keep other people from having them or give them to people that I want to give. So that's a knowledge cycle. There's also product process. It is a cycle, but perhaps not. I want to manufacture a product. In order to manufacture it, I have to have suppliers giving me components. I need to market what I'm manufacturing. I need to sell it. I need to have distributors. Then people use the product. When they use it, they maintain and repair it. They have to. And today it's fashionable that after you use it, you have to be able to recycle it. And of course, if you used it and enjoyed it, you might want to upgrade, which means we have to manufacture again. Now, anybody who lived through Corona knows that, at least as of 4 years ago, our manufacturing processes are very delicate and they have high efficiency. And if you interfere with them, you have widespread shortages, prices go up, and so on. So how can we help and hinder? First of all, you can block the suppliers. You can keep the identity of an alternative supplier secret. Now you say, oh, why would I do that? Well, if there's 50 alternative suppliers, but only one of them is any good, that's a valuable secret. I can file a patent or keep a trade secret on how I manufacture. I can have a patent on the claims that are made in marketing. I can help somebody by licensing my brand, My Little Pony, to sell pajamas. I can have patents on maintenance. And there were big arguments about it. John Deere and some photocopier manufacturers were big on preventing maintenance. There's a lot of know-how in sales, but you have to keep it from walking out the door. I can file patents specifically to scare my distributors. Okay, I'm selling in Brazil, so I file a patent in Brazil. So I can tell the distributors, be careful, if you distribute his product, I'll sue you. A few more cycles. The financial cycle. So most companies have some sort of business model. The business model tells us how revenue happens. If you know the model, you can file patents which interfere with the model's operation. You can file patents which siphon revenue away. We've talked about that in the past. A company, in order to operate, needs cash flow. If you sue them when they don't have good cash flow, then they are at extreme disadvantage. If you do timely threatening of suppliers and distributors in ways that will choke on their cash flow, that can also be very valuable. Of course, not all of this is legal in all jurisdictions. In order to get money, some companies obtain investments, or they have some corporate which has to decide whether or not to approve the budget, or they have partners. If you generate freedom to operate issues, that can definitely interfere with them getting money. If you weaken their patents, or if you show that there's workarounds for their patents, again, that weakens their ability to obtain money, which can stop them. A lot of companies have some sort of growth cycle. Maybe it's a flywheel. Wheels, I ride a bicycle, brings to mind poking a stick between the spokes. Because that's exactly what we want to do with our competitors. For example, if I give out free licenses, I might make it easier for third parties to steal or otherwise make money off of the customers of my competitor. Or I might make it easier for others to offer competing products. And the example that comes to mind is Linux versus Microsoft Server. You usually need a trademark in order to feed your growth. You can attack these trademarks. You can change customer expectations together with a little bit of IP, and that would interfere with the product market fit. The big problem with all of these beautiful stories is that timing is very important. A lot of IP doesn't operate so quickly, and suing somebody like Apple sued Samsung and winning after the product is not on the market anymore might not be very helpful. But if you file patents to block version 2.0, so where's the flywheel going to? Security and operations. In order for a company to survive, it has to be able to do something to its own competitors, including yourself. If you prevent a company from getting good IP, it not only has an effect on investors, it also has an effect on the security of the company. You don't want them to know about you because you don't want them to get relevant IP, so you could publish deceptive IP that leads them in the wrong direction. You can publish confusing business intelligence so they don't know what kind of threat you are. You can publish operational secrets. Operation is something that happens inside the company. Usually, they're kept secret. If you have a franchise, they're published because you keep on franchising it. But if you don't have a franchise, nobody knows what you're doing inside corporate. Well, if your competitor gets the wrong idea, you can catch them. More important, if you convince them that your secret, which is actually copyable, is connected to something uncopyable, like we only use people who know 5 languages. There are not enough of them to go around. So if they believe that that is the secret to your success, they're not going to be able to copy your other ideas, like we first handled tickets which have waited more than 5 days. I've been talking mostly about interfering with competitors, a little bit about helping collaborators, but IP can and should have an effect of shaping the ecosystem as a whole. And the two metaphors which I'm mixing together, or at least Dali tried to mix them together, the first one is a nuclear reactor. A nuclear reactor, classic one, has damping rods and it has fuel rods. And when you want it to run harder, you put in more fuel. When you want it to slow down, you put in more damping. If you're managing an ecosystem, as a lot of companies do, you want to make sure the ecosystem is running at exactly the right temperature. Things are happening, so you get money off of the ecosystem, but it's not so hot that people are breaking away from what you're doing. Of course, the government might not agree with you about what the right speed is. But this is very scalar. I can make the ecosystem run harder or cooler. I can also guide what happens in an ecosystem. Like in a pinball machine, I can knock things in a certain direction. The whole idea of standard essential patterns. On the positive side is that people can now practice the standard. On the negative side, I decide what the standard is going to be, and then I publish the patterns, like we just mentioned Tesla before. So Tesla is trying to guide what happens in the ecosystem, and from time to time, they do activities just like with these control rods and fuel rods in order to make things go at the right speed. In any case, this knowledge cycle that I talked about before, data turns into ideas, turns into usage, which gives you more data. It applies in the ecosystem as a whole as well. You can have one component generating the data and another component generating the ideas and yet another component using it. So when you think about where do we want to have these damping and fuel rods, you have to look at it from an ecosystem view. In summary, when you draft claims, I think you should be thinking about the knowledge cycle. From all of the different things that I talked about, I feel that the knowledge cycle is the one that gets the least attention. And perhaps one way to get used to looking at the world through the knowledge cycle is by drafting claims where inside the claim itself, you're focusing on the flow of knowledge. Second take home is that you use IP to hinder your competition, but to help your friends. For both your competition and your friends, you should learn to leverage points. When you think about IP, patent, trademark, one of the 10 different types of patents, 5 different types of trade secrets, and so on, you should consider both the essential strengths of the item, what is it good for, like I said, preventing you from doing something, convincing you shouldn't do it, and so on, and the typical uses. And last but not least, look to the ecosystem. As an example, there is a company called ZBrush, which puts a camera on your toothbrush in order to take pictures of your teeth. So you have a client called iBrush. And the question, theoretical question, is 5 ways you will use IP to interfere with the business of ZBrush, and ZBrush already exists, but also 3 ways you will use IP to guide the ecosystem so it generates value, and you can choose whether it's generating value for iBrush or for humanity, because some people want to help humanity.